Yes, Mr. Turner.
Before the break, my lord, the Master of the Rolls, posed the question, how do I respond to the wording of the regulation which refers to individual takeoffs? I have 2 points in response to this. Firstly, I would respectfully reiterate what my Lord Justice Coulson said earlier. If you say to someone who is taking a trip, where are you departing from? They would most likely answer with their first point of departure. If they said, I am departing from Kansas, then I am departing from New York, then I am departing from London, then I am departing from New Delhi, we might find that formulation rather odd. So I would not accept that it is the more natural meaning of the term departing from, that it should refer to every single stage of a stop-off on a multi-stop connecting series of flights. My second point is that even if one accepts that there is a degree of imprecision in the language read in the abstract, and that reasonable people can differ as to the interpretation of that language read in the abstract, that is, of course, not a new situation for courts. And very often the courts are called upon to interpret legislation where there is a term of uncertain ambit. And in the present case, I would submit that courts have interpreted the relevant provision and the meaning of the term departing from, and that is what happened in Wegener and the cases subsequently to that. And I've already taken the court to paragraph 15, where it set out the binary choice between a single unit of travel, which is what the airline was arguing for in that case, and multiple a single unit of travel, which is what the claimant passenger was arguing for in that case, and multiple points of departure, which is what the airline was arguing for in that case. And it sided with the claimant that there should be a single unit of travel, and that was the meaning of departing from. Finally, it's important to note on the Wegener point that Wegener is no outlier in my submission. It has been followed in subsequent CJEU cases, Cheskay and OI, and not, as I think was suggested earlier, been read down or overruled in those cases.
Well, the reasoning's quite different in Cheskay.
Indeed, my lord. Cheskay was a case which related to Article 3.5. It was not a case which related to Article 3.1a. And the suggestion that somehow Wegener is reinterpreted as a case under Article 3.5, in my respectful submission, does not work. Cheskay was a case about which of the operating airlines, or which of the airlines was deemed to be the operating airline. The scheme of the regulation is that it is the operating airline which is held liable, so only one airline will be held liable. If an airline decides to subcontract parts of the journey to other airlines, it is only the operating one which is held liable. And so that was what Cheskay was about. It was about Article 3.5, which describes which airline is to be held as the operating airline. That is quite different from 3.1a. But I do say that in passing, in Cheskay, in talking about the nature of the journey, the court did discuss the Wegener case and adopted the interpretation that I favour, namely that for the purposes of Article 3.1a, departing from means the first point of departure on a multi-stage trip.
Where's that?
The court could turn to page 355 of the authorities, which is at tab 13. This is the Cheskay judgment.
We still don't have tabs.
Mr. Gillow earlier drew the court's attention to paragraph 33 of this judgment, which is the final decision relating to Articles 5, 7 and 3.5. And the court rightly asked earlier, what has that got to do with Article 3.1? And the answer is not very much. The reasoning on Article 3.1 is to be found earlier, and it does, in my respectful submission, support what I say. That is to be found at paragraph 16 of the judgment at page 359. And this is where the court said, as a preliminary point, it must be recalled in the first place that a flight with one or more connections, which is the subject of a single reservation, constitutes a whole for the purposes of the right of passengers to compensation provided for in Regulation 261. Now, Mr. Gillow says, but there is a reference to the purposes of the right of passengers to compensation, and so therefore Article 31A, or the interpretation of a single unit, is limited to compensation. That's what he says. He says that it is limited to Article 7.
You missed the important bit out, implying that the applicability of regulation is to be assessed with regard to the place of a flight's initial departure and the place of its final destination.
Precisely, my lord. That is exactly the point that I wish to make. And that, in my respectful submission, is exactly the position that I put to the court today, that the applicability of Regulation 261, that is to say, the applicability of the regulation as a whole, determined by Article 31A, which is logically prior to any rights to compensation, is to be determined with regards to the place of the flight's initial departure. There is no limitation here to Article 7. There is no bifurcation or split between Articles 3 and Article 7.
Well, I mean, it's even better, you'd say, by 17.
Indeed, my lord. And that, my lord has anticipated my next point, that 17 goes directly to Article 31A and reiterates the same point. So that is why I say that the subsequent cases to Wegener confirm, rather than read down, the reading that I have suggested to the court. And they also confirm in my submission that Wegener is not just a case on Article 7 and is not a case which can be read as inclusionary or either way.
What is the latest case after Chesky?
OI is the latest case.
And is there any other, or is that OI is the last one, is it?
That in terms of the EU jurisprudence, OI is the last one on this.
And the last one on this point in our jurisdiction is Verano.
Indeed.
Which follows Wegener.
Indeed, my lord, yes.
Well, yeah, I'd like to look at that, if we may. Can we look at, is there anything in OI you want to belong?
My lord, yes, there is. Could I take the court, please, to tab 16, page 391 of the bundle? So, OI was a case in which a claimant passenger booked connecting flights from an airport in Spain to Frankfurt via Madrid. And the legs of the journey were operated by two different airlines, the first by Air Nostrum and the second by Air Berlin. Air Nostrum changed the flight, this is the first flight, to one which was 4 hours later, but the claimant nonetheless caught her connecting flight and arrived in Frankfurt 10 minutes before the scheduled arrival time. So she had an interim flight which was delayed, but her overall journey was not delayed. The claimant argued there, no doubt relying on the principle of passenger protection, that she should be able to recover, to get a windfall, because she had been delayed in the middle of her journey. The Court of Justice held that she could not, because it was not permissible to subdivide the journey into its constituent flights so as to benefit a passenger, even though that denied the passenger a right to compensation, even though she had been messed around by the airline, as she might colloquially put it. Could the court turn to page 396 of the bundle, please? I'd like to take the court, please, to paragraph 26. The court said, in this regard, it must be noted that a flight with one or more connections, booked as a single unit, constitutes a whole for the purposes of the right to compensation for passengers provided for by the regulation. And it cites there Wegener.
It does say, for the purposes of the right to compensation.
It does, my lord, but that rider in my submission is just talking about what was at issue in that case, which is the right to compensation.
Do they say anything about Cheska?
I'm not sure that Cheska is covered in this case. I can't see anything flicking through. But what I would, and I see from the cases cited to it, it's not among them, so I don't believe Cheska was covered. But what I would suggest is that there's no indication here of an intention to restrict that single unit concept to Article 7, compensation only. Rather, it's a general statement, but just made in the context of compensation, because that was what was being argued before.
If one was being suspicious, paragraph 26 of OI, notwithstanding the fact that Seska isn't cited, is word for word paragraph 16 in Seska. So it must be a remarkable coincidence that the CJEU speak with such one voice that the words are identical.
Sorry, just say that again.
Paragraph 16 of Seska at page 359
Yes.
uses precisely the same words as 396, paragraph 26 in OI.
My Lord is right, and I may perhaps have found the reason. The Advocate General was P. Picame in both Seska and OI. So it was the same Advocate General, which may well suggest that there was an awareness.
It changed in this regard, Peter.
Oh, right. Not quite identical.
So it's, I'm sorry, you've got to tell me this again. Paragraph 16 of Cheska is identical to 26 of
OI.
Right. One could be forgiven for thinking they weren't treating these airline delay cases with adequate seriousness.
That would be an invidious thing for me to
Unlike this court.
suggest. Those are my submissions on OI and Seska. With regards to Verano, the case that my Lord Justice Coulson has mentioned previously, I do suggest, I don't put too much emphasis on this because it is a High Court decision, which obviously doesn't bind this court, but I do suggest that it is consistent.
Where is it?
That is at tab 18, page 423.
423.
It starts at page 423.
Thank
Yes,
you.
This is Mr. Webb.
indeed. The key paragraphs of that in my submission are paragraphs 82 and 83, which are at page 441 of the authorities bundle. Where Mr. Webb said, "It is common ground that Ms. Verano should be taken as having booked interconnecting flights with Air Canada to take her from Heathrow to Austin, Texas. It was, in effect, a single booking. Regulation 261 was engaged in the present case because the flight operated out of Heathrow." And then it then went on to quote later Justice Arden as then was in Gahan at paragraph 73, where she said, "The flights are taken together for the purposes of assessing whether there has been 3 hours or more delay." And then at 83, Cheska was referred to as well as Vegena, and Mr. Webb said this analysis is consistent with the subsequent decisions of the CJU in those cases, both of which emphasised the importance of the fact that the connecting flights were booked as a single reservation or under a single booking. In the latter case, it was held that the flights with one or more connections that are the subject of a single reservation must be regarded as a single unit. So in my submission, the cases which have followed Vegena have confirmed its decision and confirmed further that it is not limited in any way to Article 7. It is a case on the outer territorial limits of the regulation, and that has been followed.
How does the EU deal with situations in which different language texts have entirely different meanings?
The EU does take into account different language texts. This goes back to cases, I think Marleasing is a case where that was acknowledged. It may not be, I may have misrecalled, but certainly the different texts are taken into account. I mean, certainly it's the EU's aim that there should not be divergences, and a reading will be arrived at which is certainly by the CJU, which is one which applies to all of them. Indeed, but what I would say on this specific point, because in answering my Lord's question of principle, I think it's worth taking us to the treatment of this precise point, which has actually come up in the cases. So, in the Schenkel case, and the court will recall, Schenkel was the case which dealt with the question of whether a outward and return a journey could be treated as one for the purposes of the regulation. This was a case from the German courts, and so, as is customary, it referred to flight in the question referred. And this was an issue which was dealt with by the Advocate General there, who was Advocate General Sharpston. She explained, just find the reference, that although the term flight was referred to, yes, here we are, it's page 77 of the bundle, at AG, starting at AG 6. And I think this was the passage that my learned friend took the court to earlier. She said, at this point, it is appropriate to note a difference between the wording of Article 3.1 in most language versions of the regulation and the German version, which forms the basis of the referring court's question. Most language versions use a construction similar to the phrase passengers departing from an airport. The German version uses the word, however, includes the word from, flight, rendering the phrase as passengers who embark on a flight at airports. And then she goes on to agree with what the French advocate had said, which is that the difference in wording does not alter the actual sense of the provision. Embarkation on a flight is the normal preliminary to departure. When passengers depart from an airport, it is understood and obvious that they do so by embarking on a flight. So what she was saying here, and I submit this is consistent with my case, is that, yes, of course, one actually gets onto a flight physically when one departs, but the question of where one departs from in the natural meaning of the term, and on this point I again agree with my Lord Justice Coulson, the natural meaning of that is departing from the initial point of departure. So I'd respectfully suggest, in answer to the question which I posed in response to my Lord the Master of the Rolls question, is that the differences between the different language versions of this regulation have been addressed in the case law, and they've been found not to be not to make a substantive difference.
What did the court say?
The court agreed. I'll take the court to that.
Did they agree expressly?
Let me find the reference. Indeed, at page 89 of the authorities bundle, the court, and this is a paragraph 24, or starting at 23, in its question, the referring court uses the term flight and refers to the concept of a journey or travel, and asks whether a flight includes a journey by air, and so on. The concept of flight, this is 24, the concept of flight is of decisive importance, and it's noted that the German version uses the term flight, but the other ones, the clear majority of the other ones don't. And then this is where they go on to endorse what the Advocate General said, which is at paragraph 8 that I just took the court to, that it doesn't matter. The divergence between the different language versions has no effect on the actual meaning to be given to the provision concerned, which determine the scope of the regulation. So the CJU has already held that the difference in language versions doesn't matter.
Well, this in many ways is more significant, since it's looking at scope and jurisdiction, and it's they had an Advocate General which they didn't have in the later cases, and I mean this does look as if it's what European law was in 2008 anyway, doesn't it? I mean, unless it's changed.
My Lord, in my submission, this interpretation of the regulation, it remains correct, that it doesn't make a difference, the different language versions.
There's never any academic writing or textbooks or anything of that kind in this area?
I have read an article in which the decision in Wegener was criticised for being overly expansive in terms of taking the ambit of the regulation out of what it should be limited to. This was a pro-airline article that was written, and it suggested that it should have, the court should have endorsed the single flight interpretation favoured by the airline in Wegener. I haven't cited it to the court. I don't think it takes us anywhere. I don't seek to overturn Wegener. Wegener is, in my respectful submission, good law and should be followed. That is the only real critical, and I mean that in the wider sense, commentary on this point that I am aware of.
And there's no, as my lord asks, there's no textbook.
I have consulted the leading textbooks on this, and they do not answer the question. They simply.
I mean, do we get Halsbury in this area?
I haven't consulted Halsbury on this. I looked more at the specialist travel textbooks.
And what are the specialist travel textbooks? Forgive me for not knowing, Mr. Turner.
Yellow on flight delay, I imagine.
Yeah, there is.
He's in all the cases as far as I can tell, so I'm assuming if he hasn't written the book, that's coming.
One would have to inquire of my learned friend, but I would have to get the names for my lords. I can't remember them to hand. There's one on, I think it's on tourist law, and there's a further one on air transport more widely, which is a loose leaf version in about six very large binders. But I'll get the names for the court if that would assist.
Well,
but in short, they don't.
I don't need to see it. But
They don't deal with this question. I did look in them, and they don't deal. They report the decision in Wegener, but they don't suggest what its implications should be going forwards. That I would suggest, though, is dealt with A in Wegener itself, B in the cases which follow subsequently, and C in Lady Justice Arden's statement in Gahan, which, if it would assist the court, I propose to take the court to now.
Mm-hmm.
So, Gahan is at tab 8, page 300 of the authorities bundle.
so Gahan came after Schenkel.
Correct, my lord, but before Wegener. And yet, despite coming before Wegener, it was entirely consistent with and correctly predicted the result in Wegener.
Although it's actually an air carrier case, isn't it? Am I right?
When my lord says an air carrier case,
I mean, it's to do with community carriers, non-community carriers.
in part, it was two joined appeals
right.
by claimants booked with Emirates, so non-community carrier, to fly from Manchester to destinations outside the EU via a stopover or a layover at an airport outside the EU, which I think was Dubai or UAE in both cases. And in these cases, the initial flight from Manchester was delayed, causing the claimants to miss their connecting flights and arrive at their final destinations much later than scheduled.
Could you be very kind and give the reference?
It begins at page 300 of the authorities bundle.
Thank you.
And the point I'd like to take the court to, please, is paragraph 33 of the judgment, which is at page 310 of the authorities bundle.
So so this was an initial flight from Manchester.
Yes.
And the delay to that initial flight meant that the passengers arrived at their final destination late.
That is correct.
So on the face of it, they had a good claim.
My lord, yes, and they succeeded.
Right.
But there were several arguments made by counsel for Emirates, and I'd like to take the court to the first one of these, the primary submission, which is summarised at paragraph 33. Mr. Marland for Emirates contended that the only relevant flights for the purposes of calculating any delay are the original flights out of EU airspace. And he said this, he said the two legs of interconnecting flights were separate flights. So he was arguing against this single unit of travel. Again, you have the airline arguing against the single unit of travel, just as we had in Wegener. And he said that the regulation is only applicable to the first leg out of EU airspace, and only this leg was relevant to the calculation of any delay. And on the facts of those cases, that would have negatively impacted the passengers, either because the journeys were shorter or because the delay was not sufficient to meet the requirements for compensatable delay under the regulation. So that was what was argued in Gahan, but it was rejected in Gahan. So this notion of treating connecting flights as separate individual flights was rejected. And we can see this in Lady Justice Arden's decision. And I'd start off, if I may, with 73. This is at page 320 of the authorities bundle. So paragraph 73, Lady Justice Arden said that the Court of Justice has held that the liability for compensation for delay depends on the delay in arriving at the final destination. Where the carrier provides a passenger with more than one flight to enable him to arrive at his destination, the flights are taken together for the purpose of assessing whether there has been 3 hours or more delay. So she's talking there about delay and about compensation. That's how she starts off, and that is what the Folkert's judgment does in terms of talking about flights as a single unit. And Folkert's is important because it informed the court's decision in Wegener. But I'll come back to that, if I may, because what she then said is particularly important for the question of Article 3.1a, which is our question, and which was the question in Wegener. She said at paragraph 77, which begins at the bottom of the page, 320, the basis of jurisdiction asserted over non-community carriers is territorial. I agree with Mr. Pomfret, that's counsel for the claimants, that there is no need for EU law to rely on the effect of delay. Now here is the really significant point, that sentence which I'd like to emphasise to the court. She said, it is sufficient if Flight 1 begins in the EU, as Article 3.1a requires. And that, in my submission, is exactly what the court in Wegener said, that the necessary factor for engaging 3.1a is Flight 1, the first flight, the flight from Manchester, beginning in the EU. She didn't say, for example, it is sufficient if Flight 1 or Flight 2 departs from the EU. She could have, but she didn't. So in my submission, this paragraph 77 does form part of the ratio of Gahan. She was, on this point, responding directly to the argument of Mr. Marland, which was summarised by her at paragraph 33 of her judgment. This is part of the ratio.
Well, it was his primary submission.
Indeed, his primary submission. This was a response to his primary submission. So this reference to it is sufficient if Flight 1 begins in the EU as Article 3.1a requires, that is the ratio, and this is the ratio on Article 3.1a. At paragraph 80, which is over the page on page 321, Lady Justice Arden then went...
I thought everybody accepted that this was not binding and it was obiter.
My lord, the obiter point is paragraph 80, which I'm about to read. The non-obiter point...
Well, you say the point that matters is not obiter.
Yeah, I do, and I say that the point which is... I say the paragraph which is obiter is a logical extension of the non-obiter point, but the non-obiter point is at paragraph 77. And so emphasis is to be placed in my submission on paragraph 77, on this sentence at the bottom of page 320.
Yes.
Paragraph 80 is helpful to my case in my submission, but I don't suggest this is paragraph 80 is binding, although, of course, it was the opinion of Lady Justice Arden as then was. And she correctly predicted the situation in my submission that we have in this case. She said, inevitably, there will be cases where the remedies conferred by Regulation 261 produce some odd results, although, as Mr. Gillow has accepted, there are odd results either way. For example, it is possible that no compensation for a delay on a flight which starts outside the EU and has several legs, some of which take place in the EU. And then she went on to describe a slight change to the position in Falkirk's. So paragraph 80 was obiter, but paragraph 77 was not, and in my submission paragraph 80 is merely a extension of paragraph 77. So those are the cases which have come subsequent to Wegener. Now I know that we have discussed Wegener in some detail already, but I would be grateful if the court could just turn up Wegener, as there are a couple of points which I'd like to draw out on it. That is at tab 11, page 345 of the bundle is where it begins. And this is important for the argument which is stressed by my learned friend, or was initially stressed by my learned friend, that Wegener is solely a case under Article 7 and not a case under Article 3. And by way of reminder, in the grounds of appeal, the first ground of appeal is put solely, or at least in the official grounds of appeal, it's put solely on this basis. If the court wants that reference, it's tab 1, page 14, paragraph 3, where the ground of appeal is explicitly said that Wegener is only an Article 7 case. Now, in my submission, that is flatly contradicted by the wording of Wegener. As my Lord Justice Coulson pointed out earlier, Wegener mentions Article 3 some 7 or 8 times, and Article 7 not once. The innovation in Wegener, as I mentioned earlier, was to apply the reasoning of the Falkirk's judgment, which confirms that a connecting flight forms a single whole, to Article 3, which is the article on finding jurisdiction. And so, in effect, what the court did in Wegener was it merged the concepts of single connecting flight, a single unit of travel, in Article 7, the compensation article, which had previously been at issue in Falkirk's, and it applied that to Article 3, much to the benefit of the passenger in the Wegener case. And this, I would submit, is an example of coherence being found under the regulation and within the scheme of the regulation, where the jurisdictional ambit matches the circumstances in which compensation is available. Both of them apply to connecting flights as a single unit. The CJU in Wegener was originally referred a question by the German court, which referred to the word flight. So could I ask the court please to turn to page 347 of the bundle? Since the word flight appeared only in the German version, the court was keen not to make its judgment dependent on the word flight. It didn't want to talk about it. And that is why, at paragraph 11, on page 347, the court reformulated the question asked of it by saying that it should be considered that, by its question, the referring court is asking, in essence, whether Article 3.1a of the regulation must be interpreted as meaning that the regulation applies to passenger transport effected under a single booking and comprising between its departure from an airport situated in the territory of a member state and its arrival at the territory situated in a member state a scheduled stopover outside the EU. And in that case, there was a change of aircraft, as there was in this case. That was the question that was asked by the court. And I've already pointed the court to this binary set of alternatives, which it then described at paragraph 15, so I won't go to that again. I would though ask the court please to turn over the page to page 348. And this is where the court introduces its discussion of final destination, which was used in the Folkert's case. And it took that concept, the concept of final destination, and this is the passage starting at paragraph 17, noting that it's defined in Article 2H of the regulation. So the regulation itself contains references to a single unit of travel constituting multiple flights. That is Article 2H of the regulation. So that's what the court is noting here. It then went on to cite Folkert's and to explain why a change of aircraft makes no difference. It was argued in this case, in the lower court, that the change of aircraft made a difference, but that point now is, I think, abandoned. And then, in its ratio, at paragraph 25, the court answered the question which it had posed for itself, taking into account the aforementioned considerations, i.e. this concept of a single unit of travel. The answer to the question referred is that Article 3.1a of the regulation must be interpreted as meaning that the regulation applies to a passenger transport effected under a single booking, and so on, with multiple stops. So the question posed was under Article 3, that's paragraph 11. The question answered was under Article 3, that's paragraph 25. There is no room at all in my submission to argue that this is an Article 7 case. This was an Article 3 case, and therefore an argument that Wegener must somehow be read down.
I don't think he really put it like that. I think I understand he did in writing, but I don't think he did it orally. I think he said, not that it was an Article 7 case, but that it could equally be decided under Article 3.5.
My Lord, the Article 3...
could have been decided.
Understood, my Lord. The Article 3.5 is a point which seems to have arisen, so far as I can tell, for the first time in oral discussion today. But as I have said earlier, CS was a case about Article 3.5, because CS was a case about the operating carrier. And that was where this reference to Article 3.5 arises. Perhaps it would help to take the court to Article 3.5 at this stage. It's at page 506 of the authorities bundle. Top left of the page. It says, this regulation shall apply to any operating carrier, and the definition of operating carrier comes above in Article 2, providing transport to passengers covered by paragraphs 1 and 2. So, paragraphs 1 and 2 are paragraphs 1 and 2 of Article 3. Article 3.1 is logically prior to Article 3.5. Article 3.1 is doing the work on the jurisdiction rationi personae, or territorial jurisdiction. Article 3.5 is merely clarifying the point with regards to who is the operating carrier. If you have a choice of different airlines which have flown different legs, that's all Article 3.5 is doing. It's not a jurisdictional clause in that sense, and that's made clear by the fact that it refers back to the jurisdictional clause, paragraphs 1 and 2. I've covered already the case law following Wegener, but I think it is worthwhile saying a word or two about the two cases from other jurisdictions that my learned friend has referred to. I don't propose to take any point on the admissibility of those cases. As my Lord, the Master of the Rolls, said earlier, the court can of course take them for what they are. The first case I'd like to deal with very briefly is the Frankfurt civil chamber case at tab 15.
Page?
Of the which is begins at page 378.
Thank you.
And in this case, I accept it may have been a slip in the skeleton. There was a suggestion at paragraph 49 of Mr. Gillow's skeleton that his approach is consistent with German courts, plural. But I accept, I'm assuming that was a slip, and this is the only German court which has made this decision. But leaving that aside, even on its own points, this decision is flawed and wrong in my submission, and that can be seen from page 387 of the authorities bundle.
What level is this court?
Well, this is part of what the parties were at odds with in correspondence, respectively, my lord, because we asked for some German. We asked for some form of an opinion explaining all of these points, and when we were told that they would simply be cited for what they were. So my understanding is that it is an appeal. So and Mr. Gillow may well correct me, but it is an appeal within the district of Frankfurt. So it's the LG Frankfurt Civil Chamber 24. But I am at a loss, frankly, as to what status that has within Germany, whether it is binding on other Frankfurt courts, whether it's binding on all German courts. I can't say what the position is there, and with respect, that's
I
a
don't
point
think they
not
have
for
a
me.
doctrine of precedent like we do, but it's unusual even to find this kind of decision recorded.
Indeed, my lord. But regardless of the status of it,
Anyway, it's deeply flawed, you say?
I do say it is deeply flawed, and that is for the reasons on page 387 of the reasons they give on page 387. So the part I'd like to take the court to very briefly is I'm afraid the paragraphs aren't numbered, but it's the fourth paragraph down where they say, first of all, this is the second sentence, it should be noted that in its judgment of 31st of May 2018, and that's the Wegener judgment they're referring to, the ECJ confirmed by implication the definition of the term flight, in inverted commas, Flug, in the German. So we can see from the very outset that they're talking about something which Wegener expressly didn't do. As I've just explained, the court in Wegener reformulated the question at paragraph 11 not to use the word flight. And so, with respect, the German court here has erred in saying that the term
I don't see which bit are you saying?
So this, where they say that it should be noted, this is the fourth paragraph down, in the middle of the page, on page 387 of the authorities bundle.
The case is not comparable to the present one.
Yes. I think that the first sentence is not relevant, but the second sentence, the passage beginning on the second sentence, this is where they talk about Wegener. This is where they purport to interpret Wegener. And they say that Wegener was a case which interpreted the word flug, or flight. And with respect, that is not what the CJU in Wegener did. It expressly did not do that. It chose not to. And they then go on to...
It says by implication.
Indeed, but...
The rest of it's right. The carriage here consisted of 2 flights.
That is a quote from paragraph 12 of Wegener, and that paragraph 12 of Wegener was actually cited to the court earlier by Mr. Gillow, and there was discussion of this point this morning. The point here is that paragraph 12 was just one of the introductory paragraphs where it is the factual background is being laid out. It's not an operative paragraph saying that the fact that there were 2 flights, which of course is absolutely undeniable. There were 2 flights as a matter of fact. The question was whether those 2 flights should be treated together. But instead of going through the whole of the reasoning in Wegener, what the German court here seems to have done is it seems to have stopped at paragraph 11. And respectfully, as my Lord Justice Coulson pointed out earlier, that's not the right way to approach the judgment. One needs to look at paragraph 15, 16, 17 through to 25. And it's plain, for example, that the German court has ignored paragraphs 18 to 19 of Wegener, which say that, and we looked at these earlier, but they say it follows that the term last flight, and from the term last flight, that the concept of connecting flight must be understood as referring to 2 or more flights constituting a whole. So we've got this transition from multiple flights to a whole. And the problem with what the German court has done is it's stopped reading, or it appears to have stopped writing about anything other than paragraph 12.
From this it follows that the ECJ continues to assume that in principle successive flights are to be considered separately.
Quite, and that's...
Well, it gets better after, slightly better after
I mean, that sentence is wrong.
Indeed, my lord. Indeed.
But the last 6 or 8 lines are, as I say, better. Says that it's all about protection, high level of protection for passengers, which seems to be correct.
My lord, I don't disagree with these general observations.
What decision did they reach now?
In this case, the decision was in favour of the passenger. So they said that Wegener could, the circle could be squared, but they don't explain.
And what were the flights?
The flights in this case, they were from Santiago, Chile, via Lima, Madrid to Frankfurt, and Madrid to Frankfurt. So it was a flight ending
and it was the Madrid to Frankfurt leg that looks to be the problematic.
The reasons I've given, the reasoning is flawed, and it is a misreading.
What I didn't understand is under Wagoner why that wasn't covered. Oh, I see, it's the wrong way around.
Yes.
Flying into the EU.
Flying
It was a foreign carrier.
I believe that's the case. Yes. So, in my respectful submission, these wide-ranging references to passenger protection don't get one out of the difficulty of what Wegener actually said, and this was a point which was put to my learned friend earlier, who admitted that the circle needed to be squared, and was put to him in the lower courts, and he said that the passenger needs to have their cake and eat it. But in my respectful submission, that's not the case, and so this German court, to the extent it is persuasive in any way, I would say is wrong. The second decision, or opinion rather than decision, which we've had this morning, and we're awaiting the translation of, I'd respectfully say is likewise distinguishable. Again, for the reasons mentioned by my Lord Justice Coulson earlier, namely that it was a EU carrier, and so we weren't looking at Article 3.1a at all. This was an Article 3.1b case. And the EU decided in distinguishing between Article 3.1a, which refers to non-EU carriers, and Article 3.1b, EU carriers, to create a policy distinction between the positions of the two. And one can see why the EU, from a policy perspective, may have decided to put more onerous requirements on EU carriers than non-EU carriers. And indeed, that may well have assisted the EU carriers in getting more passengers if they wanted to have these greater protections. Whereas if people book with non-EU carriers, their protections are lowered, as they're not subject to certain of the protections. So I do suggest that this second opinion, and it is only an opinion, so it is not even formally of persuasive value, at least under the relevant Brexit implementing laws, which refer only to decisions post-Brexit of the CJEU. This is only an opinion, and it is an opinion on a different point. So those are my submissions on the interpretation of the regulation, generally speaking. I propose very briefly to, or relatively briefly, to refer to the principles that the claimant has relied on to square this circle, to somehow find a formulation whereby Wegener can be banked and extended. The first is the protection for passengers principle. Please could the court turn to tab 30 at page 583. Sorry, in fact, let's go to tab 20 rather than tab 30. Tab 30 is the English version of the regulation. Tab 20 is the original regulation.
Which page?
This is page 503. 50.
50.
Yes. Apologies.
We still haven't got tabs.
I'm sorry for that, my lord. Yeah, so page 503. This is the recitals to the regulation. And the protection for passengers principle stems, and I think this is common ground, it stems from the first recital of the regulation, which is typically invoked, and as Mr. Geller has pointed out, it is invoked in every single one of these cases. I do a lot of these cases in the county court as well. And it is typically invoked in favour of the claimant as a sort of cure-all for any ill. But it's important to look at the wording of this recital. It said this: action by the community in the field of air transport should aim, among other things, at ensuring a high level of protection for passengers. So in my submission, there we have it from the very outset. Protection for passengers was not the only policy imperative that was informing what the legislature was doing. And in fact, that can be seen through the various compromises that were reached in the regulation as to its jurisdictional ambit. And that there was quite considerable discussion as to how far it should apply in terms of the territorial ambit. That is something which was actually saved for further discussion by the CJU, and that can be seen at Article 17, which is at page 509. So the Commission shall, it says in Article 17, the Commission shall report to the European Parliament. So let's come back and discuss this later, because there's obviously a lot of controversy over this point. On the operation and results of this regulation, including the possible extension of the scope of this regulation to passengers having a contact with a community carrier or holding a flight reservation which forms part of a package tour. So the precise potential extension there is not especially relevant, but the point I do wish to emphasise is that compromises were reached in the drafting of this regulation as to what its ambit should be, and that is reflected in Recital 1. So Recital 1 is it shows that it's not purely only about protecting passengers, although of course that is important. The next authority I'd like to take the court to is the hand-up, which I believe has a yellow tab, and I hope has now been emailed to my Lord the Master of the Rolls in electronic form. This is a passage from the Trade and Cooperation Agreement between the UK and EU. It is the one I'd like to refer to is AAR TRN 12. Now, in Lipton, it was pointed out that these principles in the EU in the TCA could be an interpretative aid for courts in applying the retained regulation of the regulation. Article AirTran 12 is important because it emphasises that doing business, the interests of airlines, is also to be taken into account. It's not the be-all and end-all, but it's to be taken into account. The parties agree that obstacles to doing business encountered by airlines would hamper the benefits under this title. The parties agree to cooperate in removing obstacles to doing business. So I don't say this is directly on point. One can think of formulations of doing business where doing business is not hampered by this. But the point that I seek to make is that there is a balance between passengers and airlines. This was recognised in the TCA. So the point in the TCA that the court has in the bundle at tab 23, page 525, is AirTran 22, consumer protection, which was of course referred to in Lipton. And the parties share the objective of achieving a high level of consumer protection, of course, and that was mentioned in Lipton, but it needs to be read alongside other principles, such as AirTran 12. It's not, AirTran 22 is not the end of the story in my submission.
I don't think I got given AirTran 22.
That's in the bundle itself.
It's in the bundle.
That's at page 525 of the
Thank
bundle.
you.
In terms of the authorities...
So just before we go on...
I'm sorry, yes.
Can we just... so this had become 524A. Is that right? Because this is an
yes,
earlier
yes,
part
yes,
of
that
the
would be
Trade
the
and
appropriate
Cooperation
place.
Agreement.
Yes,
We've got AirTran 22, But this is an earlier
Indeed,
clause.
it's part of the same, exactly.
Well, I put it in at 524A.
I'm grateful, my lord. I'd like to take the court briefly to the authorities on the protection of passengers principle, the first of which is IATA.
Where does
Yes.
the point go? I mean, high level of protection. I think Mr. Gillow accepts that that the principle doesn't mean that a passenger always wins. So what else do we get out of? It's agreed it's a high level of protection. That's what the recital says. That's what the cases say. It's agreed between you, rightly, that it can't be a complete answer every time. So what's the point that arises between you on the protection from passengers?
My understanding of Mr. Gillow's case is that he admits that there are difficulties with his proposed interpretation of Wegener, such that you can maintain the benefits to the passenger in Wegener, but you would extend that same principle to a passenger in his client's situation. What he says is that the protection for passengers principle is the bridge over that gap. He says that one can strain to find some kind of a reading of Article 3.1a, although the formulation of such reading I respectfully submit is obscure, but he says you can strain to find some reading of it which assists his client, but doesn't negatively affect the Wegener passenger, and the way to do that is the protection of passengers principle. But I agree with your lordship's basic point that it doesn't take us particularly far right away.
Well, I mean, do you have something beyond Lipton that shows us that the protection of passengers principle is limited?
I do. That's the point I'd like to take the court to in IATA,
Okay.
if I may.
Right.
And can I ask the court to please turn to page 49 of the authorities bundle, at paragraph 124. So IATA is a case which is relied upon by my learned friends, but in my respectful submission there are points of assistance for me. So paragraph 124 of the Advocate General's opinion, the Advocate General said, in striking a balance between the different interests at stake, that is to say, those of air carriers and those of passengers, the community legislature took into account and so on and so forth. But the point here I'd like to make is that the Advocate General emphasised that the community legislature was striking a balance, and to my Lord Justice Coulson's question earlier, isn't striking a balance only relevant in the question of extraordinary circumstances? IATA was not an extraordinary circumstances case. IATA was a case about the viability, the constitutionality of the regulation as a whole. And the Advocate General here is making the wider general point that the regulation does strike a balance. So that's the first authority on striking a balance. The second
But
authority...
how, other than extraordinary circumstances?
I'm sorry?
How does it strike the balance?
In the general drafting of the regulation.
Well, yeah, but we have to interpret the drafting.
Indeed, but
And IATA was a case where the argument was unsuccessful.
that is correct, but the observation remains that a balance was being struck.
Okay, so but that's saying no more than that the regulation was the product of detailed give and take by a number of interested parties, including the airlines.
Correct, but I would say that that is all I need to say on the striking a balance point. That the protection of passengers principle is important, but it does not override all things, and that has been repeatedly pointed out. There are references to similar points, and perhaps this comes out more clearly in the opinion of the Advocate General in Schenkel, which I take the court to now. That's at tab 3, page 81. So the Advocate General here in Schenkel, who was Advocate General Sharpston, said this: starting at paragraph 36. It is evident that Regulation 261/2004 seeks to ensure a high level of protection for passengers. So she's referring to that protection of passengers. But then, importantly, she says in the following paragraph, it is equally clear that Article 3.1, so the article that we are talking about now, limits the scope of that protection, and goes on to talk about the debates that came through the travaux. So these things are all in my submission relevant to the interpretation of Article 3.1 in circumstances where a essentially contra legem interpretation is being urged on the court, or at least a interpretation which goes against the decided case law of the court is being urged on the court.
I mean, all passengers departing from an airport located in the territory of a member state are covered is simply not right. If you're right.
I don't place any importance on that observation in the second sentence of AG 37. I simply use this to make the point that the Advocate General, who reviewed all of the travaux, can be seen from the following page and a half.
The problem is, because of this sort of rather strange, distorted construction of the word depart, everybody ties themselves in knots because they forget that it's a simple word like depart, which you use in every sentence when you're talking about airlines, means something highly specialised. So, trying to interpret all these different dicta is exceptionally unhelpful. This certainly doesn't give any support to the meaning of the protection of passengers principle. But anyway, on you go. We got any more?
And the third sentence is equally coming back the other way.
Yeah, exactly.
My lord, I won't.
However, Eleanor Sharpston did, as she once told me, work in 9 languages. So she would have been the greatest expert on the difference in the texts of the various regulations.
Is there anything in the fact that the regulation talks of passengers departing? Because my Lord's question this morning about where are you departing from? Kansas. One can see the logic that underlies that. Whereas if you could more readily say, well, what time's your connecting flight depart? There is, to that extent, in English language, a possible difference.
If the question is on the premise of connecting flight, then the answer would be about connecting flight. But
You would certainly say.
But if the question, it depends what the major premise of the question is, I think. Because if you said, what time does your connecting flight depart, the answer would be, my connecting flight departs at X. If the question is, what time do you depart, then, in my respectful submission, the answer, more natural meaning is the answer given by Lord Justice Coulson. But I think to an extent, the first response that I had to my Lord, the Master of the Royal's question earlier, and my Lord's question just now, is in a sense irrelevant to looking at the natural meaning in circumstances where we have court interpretations of that meaning in Wegener and the subsequent cases which favour what I say as the natural interpretation. It may be that other people would say the natural interpretation is the other way, but in the face of several decided cases, both of the CJU and also that of Lady Justice Arden in Gahan, one doesn't even need to go back to the regulation itself. Because if Wegener had gone in a different direction, then we wouldn't be having this debate now.
But it's a purposive construction, and the purposive construction is, if, I mean, you, I think, would say, if they're right, is complicated, because you might get involved with when you break up a single journey. But I suppose so that you'd have to look at it as a single journey if it was continuous and straight through half an hour, with very short stopovers. But if you had a longer stopover, I still think that makes it rather complicated. Is it really a single journey? If, for example, you have two tickets, not that anybody has a ticket, but you have two booking references now, and you're going to stop in London and you might want to stay in London for 2 days, are you really departing from Kansas to go to, where it was, Hong Kong, or are you going on a world tour and spending 2 days in London?
My Lord, indeed, and this is in fact a issue which I gave some thought to in preparing for this appeal, the question of when does a connecting flight cease to be a connecting flight. There is a distinction which is adopted by the airline industry, which is the distinction between a layover and a stopover. A layover is a short stop which is purely for the purposes of connecting, purely for the purposes of travelling, and typically is less than 24 hours, although one can see circumstances in which a stop purely for the connection of travel may need to be greater than 24 hours. Let's say if you're travelling to somewhere very remote and flights only leave every 2 days, one could see that you may need to go above 24 hours. I think the key distinction, though, is the distinction between whether you are stopping purely for the purposes of onward travel, or whether your stop in a certain destination is for some ancillary purpose, like sightseeing, business, and so on and so forth. I think it's a question of fact and degree, but in broad terms, then this is what was expressed by Lady Justice Arden at paragraph 73 of the Gahan judgment, where she talked about directly connecting flights, and the reference is page 320 of the bundle. She used the phrase directly connecting flights.
I mean, the logic would be if you came on a trip where you were spending 2 days in London, 3 days in Singapore, 3 days in Sydney, that you'd be protected on the flight leaving London, because you'd have your journey was departing Kansas, then departing London, then departing Singapore. But that makes sense to me. But as you say, it's if it's all one booking. I mean, what if they book it and there's a stopover of 28 hours? When you discover that, you say, oh, jolly good, I'm going to go and stay in the Ritz and have a really nice time in London while I'm there. Is that the same as having an appointment before you book and saying, I need to go to an appointment in London for 2 hours, but it's only very short and then I can fly on? I mean, all these things you can imagine being quite difficult.
I fully accept that. And it is interesting, and I've looked for cases on this, it is interesting that no case on the definition of connecting flight has come before, so far as I can tell, any of the courts, certainly not the UK courts in a reported fashion, or the EU courts. And I fully accept that there may be some edge cases like the situation that you described. But as a general point, where the purpose of a connecting flight is purely to travel to the next stop, and it's not for ancillary purposes like business sightseeing and so on, as I've mentioned. And part of the evidence for that would be how long you are stopping off and whether there were sooner flights that you could have taken. If, for example, you choose not to get the closest connecting flight and you choose to get a later one so that you can have 24 hours in London, as the case may be, then I think it would be very difficult to say that was a connecting flight. But those are not questions I think that the court necessarily has to answer.
Well,
today.
I mean, it is quite important for the non-discrimination argument, which I know Mr. Geller didn't make very much of, but it would genuinely be discriminatory if passengers arriving at Heathrow from the Ritz, I'm sorry to use the Ritz, but all arriving together from the Ritz to go to Singapore, some were covered and some weren't, because one came from America the day before and one didn't. Whereas if you're joined on your flight to Singapore from somebody who's just literally laid over for 2 hours from New York, you could understand that it was purely incidental that you were stopping in the EU.
If one's looking at it from the
It looks much less discriminatory, is the point I'm making.
in my submission, that there are, with any application of this regulation, going to be discriminatory effects, not just in the, provided one agrees, which I think is clear for all of us, that it doesn't apply to every flight, every passenger worldwide, but from the average passenger's perspective, the fact that if you compare the London passenger to the Agadir passenger who gets on Ms. Vigena's second flight, they might think of it as equally unfair and equally discriminatory, and they might not care at all that they're
You would
Agadir
also
as opposed
say,
to London.
wouldn't you, that it's to protect citizens of the EU.
Well, I think that's
its
a reason.
primary objective.
I think that's a reasonable reading of EU legislation. That is where it's.
So that's why I wondered if you got more help from the recitals. But you don't.
I'm not sure that the recitals do particularly assist on that point, but turning to the non-discrimination point more generally, there are all sorts of discriminations in this regulation which are inherent in its structure. For example, if a flight is delayed for 2 hours and 59 minutes and 30 seconds, which by way of an aside actually happened to me once, then there is no right to compensation at all. You're simply left there with your delay. And so there are arbitrary lines, or somewhat arbitrary lines, which need to be drawn. I would respectfully submit that the line drawn by the Vegena case, which is where you don't depart from the EU, it is not such an arbitrary line. And that is for the reason given by my Lord Justice Coulson earlier, that whereas the point of initial departure and the point of ending of a flight, those matter, because you want to you can only start in one place and you can only finish in one place. You want to get to your destination and you want to get there from where you're travelling. But where you stop off, in my respectful submission, that is, in my Lord's words, an opportunistic lottery. Why should it make a difference if you fly from the UK to India via Geneva, or via Agadir, or via London? It is an opportunistic lottery as to where you stop off. And indeed, on my learned friend's case, if a flight was diverted and it was planning to fly from, say, New York to Marrakesh, and instead it was diverted and had to stop off in southern Spain, all of a sudden the passengers would become entitled to compensation under the regulation, just purely by virtue of being diverted, whereas if it had flown directly and been delayed, they wouldn't be subject to compensation. So there are aspects of unfairness in any way that one cuts the cloth, but I would respectfully suggest that there is a logic to the way in which the regulation was drafted and has been interpreted in terms of this single unit of travel concept with one starting point and one finishing point, a single point of departure and a single end. So again, similar to the passenger protection point, I know this one was put less forcefully by my learned friend, but similar considerations apply. It's not a trump card that can override the wording of legislation, and it's not a trump card that can override judgments of the CJEU. And one thing that's important to take into account in the English court's use of EU principles, which is, of course, acceptable, albeit that they can be overruled, and that's common ground between the parties. But those principles must be mediated through what the CJEU has actually decided. These principles don't exist in the abstract. They only exist insofar as they are recognised by the courts of the EU. And in my submission, where those principles come to be applied to our scenario, the interpretation of Article 3.1a, the CJEU has laid down boundaries, and those boundaries exclude the claimant's claim. So notwithstanding these principles' application and validity in the abstract, when it comes to actually applying them, the Court of Justice of the EU has declined to do so in favour of passengers. And that can be seen in the OI case, where the passenger wanted to break up a flight into its constituent parts because she was delayed on one part of it, and the Court of Justice said no. Notwithstanding equal treatment, notwithstanding protection of passengers, you're not entitled to this. And interestingly, on the equal treatment point, had the passenger in OI just been flying the first leg, she would have been entitled to compensation. And so everyone on the first leg who flew that first leg was entitled to compensation. But because she was flying a second leg, she was excluded from compensation.
Well,
So
I
that-
wondered about that. Is that right? If there is a flight, the flight to Madrid was very late.
Yes.
So the passengers just doing that flight would have had a claim.
Yes.
But because she was flying on, she didn't have a claim.
Correct. Correct, because her final flight was not delayed. And so there is, on the CJU's case law itself, arbitrariness and unfairness. That is just a consequence of there being outer boundaries to the right of compensation under the regulation.
A few minutes ago, you started a submission about, which I thought was drawing a distinction between stopovers and layovers.
And
you said
yes.
that a layover is as it were, a 2-hour stop for refueling or whatever. What's a stopover? And does it actually have technical meaning? Because it features large in the decision in Vigena.
I think courts have tended to use the term stopover and layover interchangeably without looking at their technical meaning. The technical meaning does not, so far as I'm aware, have any basis in law. It's something which is adopted by airlines in terms of their structuring, and it's important for things like crew welfare and so on, and the rights which are given to crew.
Does that hold the key to what my lord, the Master of Rolls, was asking you about his visitors from the Ritz?
Well, it does in part, but I can see
some of them may not have been on a stopover.
Yes. No, so to clarify, this was more of a response to the question on when does something cease being connecting flights. It's not something I rely on for my case here, but I can see there being some logic in using the stopover versus layover distinction, which is essentially between a 24-hour stop and a shorter stop, as part of the test for when something is a connecting flight. I can see, though, that there are situations where the stopover layover distinction may not work. Let's say you're flying to the Arctic Circle and flights only leave from northern Norway every 2 days because not many people fly and it's not very economical to fly. In those circumstances, you would be forced to have a stopover, as far as I can tell. So in those circumstances, I can see that there would be reason to treat all of that as a single unit of travel in those circumstances. But for my case, I don't say it matters.
You're almost reducing it to a question of fact in every case.
No, I think it would be helpful to lay down some criteria. As a general matter, in terms of assisting consumers and airlines, I think it would be helpful to lay down some criteria. I don't offer a particular test as to that because I don't think it's not a point at issue in this case. If it would assist the court, I could certainly do so.
Shouldn't be laying down criteria that don't arise from this case.
Well, indeed, that is why I haven't done so. But those sorts of considerations, I think, would be helpful in terms of determining what is a connecting flight should the question arise in future litigation. One thing that's worth noting is that the Commission did propose a new version of this regulation in 2013, which did define connecting flight. Not very helpfully, but it was actually acknowledged by the Commission in that draft regulation to update the present regulation that connecting flight is something which ought to be defined. And that may be a question for the courts, it may be a question for Parliament in due course, but I would respectfully say I don't think it's a question which needs to be decided today for present purposes, because I don't think there's any dispute between the parties that these were directly connecting flights or that Ms. Chelluri booked on a single ticket and booked all these flights all at once. I will very briefly now deal with the alternative ground of my learned friend that Vigena should be overruled. As my learned friend said, that there is no debate on the principles for this, which is whether whether it would be right to do so. The same test is applied by the Supreme Court for departing from its own jurisprudence. As the court will probably be familiar, the Supreme Court in the Willers and Joyce case, which is at tab 10, page 340 of the bundle, dealt with this issue when looking at the question of precedence, and it was sitting as an exceptional panel of 9 justices in this case. And at the end of paragraph 7, Lord Neuberger noted that the Supreme Court should be very circumspect before accepting an invitation to invoke the practice statement to depart from its own jurisprudence. More recently, as the court mentioned earlier, the question of when to depart from EU jurisprudence was looked at in the Tune-In case by this court, which you'll find at tab 19, page 470. And again, in this context, in this precise context of departing from EU jurisprudence, the Court of Appeal said, at paragraph 75, the House of Lords and the Supreme Court have consistently stated this is a power to be exercised with great caution. And there were some reasons given on the following page as to why it would not be appropriate to depart from the case law of the CJEU. And 2 of these are quite important to the present case. They are, firstly at 78, there had been no change in the domestic legislation in question, and so it was the will of Parliament that the legislation should remain in its current form. And in my submission, I don't think there's any dispute on this point, the relevant part of the regulation, 31A, is retained in materially the same form, just that the UK is substituted for the EU in terms of where you've got to fly out of, where you've got to depart from. So the fact that there's no change in the domestic legislation is a powerful reason not to depart from the EU jurisprudence. And secondly, and this is at paragraph 79, there have been no change in the relevant international legislative framework. And in our case, that is the Montreal Convention. There's been no change in the Montreal Convention between Wegener and now, such that there is, in my submission, no good reason to depart from Wegener. In this case, the test is not met. So, to conclude, I respectfully submit that the claimant's 2 grounds of appeal should fail. The claimant's arguments on this appeal would entail a dramatic widening of the ambit of the right to compensation, and as the court has already mentioned, this would have massive commercial consequences. Now, that is not a reason of itself to reach a certain decision, but in circumstances where there is binding EU jurisprudence, or at least highly persuasive EU jurisprudence on this exact point, where there is Court of Appeal authority on this point, it would not, in my respectful submission, be appropriate to fashion a new rule that somehow allows Mr. Gillow's client to have her cake and eat it, as was put in the lower courts. This is undoubtedly a case where the result will matter to many people, but it will also matter to many airlines which operates flights which connect through the UK. It may be that the UK wishes to depart from the EU position at some point, but I'd respectfully submit, if there is to be a widening, as the claimant argues, that's a question for Parliament, and not something that the courts should decide to do. I'll just check with my instructing solicitor if there are any further points he has. Unless I can assist the court further.
Thank you very much, Mr. Turner. Yes, Mr. Gillow.
Thank you, my lord. My lord, I wanted first of all just to address the very interesting submission that my lord, the Master of the Rolls, made concerning...
I didn't make submission.
Sorry, I do apologise.
I gave that up some years ago, Mr.
Yes.
Gillow.
Do apologise, my lord. The point that my lord made concerning this issue about stopovers and layovers and when is a connecting flight not a connecting flight.
Yeah.
And I do think this raises some interesting questions. But in my submission, the way to cut through this would be to say that each individual flight, in the ordinary meaning of the phrase, brings you within the scope of the regulation. And then you've got the separate question of how do you calculate compensation? By what do you calculate compensation? How long have you been delayed? How far is the reference? And how far is the distance? And all of that is done by reference to the delay on arrival at your final destination and by reference to the place that you first started your journey from, because that governs the inconvenience that the individual passenger has suffered. So to take my learned friend's point about the case of OI and the lack of equal treatment there, it's clear to see how that lack of equal treatment, insofar as there was any, was entirely justified. Because for a passenger starting their journey in Madrid and flying only to the next stop, the inconvenience they suffered was the delay on arrival at final destination. But for a passenger such as the claimant in OI, who was taking the entire trip from start to finish, all they were concerned about is how late they got to their final destination. All the Court of Justice has said, all that they were concerned about is, I accept that there might be some limited inconvenience suffered by reason of a single flight being delayed, but the Court of Justice has made continually the point that what the individual passenger is really interested in is when they get to wherever they're finally going to. And my lords...
So that brings us back to the question as to who you're comparing them with.
Indeed, my lord, yes.
And that's the difficulty, I think, with the equal treatment part. The high protection for passengers, I completely get. The equal treatment point keeps bringing you back to, well, who are you comparing them with? Because I understand that submission completely, but that means you're not comparing her with the passenger sitting next to her if the passenger sitting next to her was getting off at Madrid.
No, absolutely, my lord. But you would
So then so in this case, who are you comparing the claimant, the appellant, with?
I think the answer to that, my lord, must be that you're comparing the claimant to somebody who is aiming to arrive at the final destination of the appellant, or the claimant, on the same flight. So if you take the case in OI, where they were travelling from Madrid to wherever they were travelling...
Southern Spain to Madrid, I think, first.
Yes. The second leg of that flight, someone starting that second leg and ending at the end of that second leg, that second flight, would be suffering the same inconvenience because they would also be suffering the delay on arrival.
Yeah.
If they were taking a second flight and going somewhere else, and that flight they could catch on time, then there wouldn't be any issue there, if that makes sense.
I understand that, but it then becomes highly... It's not simply comparing one group of people with another, it's actually quite specific.
My lord, yes, and I do think that the issue with the equal treatment provision will always be that it does raise some quite specific comparisons that you have to look at. I would, however, submit that it's a much simpler approach, nevertheless, than looking at the motivation of an individual passenger for which flights they took to get from A to B. So if there's a situation where the courts have to consider, in the case of someone flying from London to Singapore via Dubai or wherever else it might be, well, why did they stop at Dubai for this length of time? What was their purpose to do this? What was their purpose to do that? Did economic considerations make a decision in which flights they booked? That presents the court with a really difficult, potentially difficult, factual exercise, which might require witness statement, cross-examination, and a considerable amount more work in resolving these cases than would be taken if you simply said the flight applies because it took off from an EU airport or a UK airport. And then the question is, what inconvenience has the passenger actually suffered? How late did they get to wherever they were aiming to go? My lord, those would be my submissions on how you deal with that particular point. And in my respectful submission, that leads directly to the point that my learned friend made about the cases of Gahan and Verano. Because if you look at those cases, and I note that I was counsel for the claimant in Verano, what the case was concerned with was whether or not the ambit of Regulation 3.1a and 3.1b had extraterritorial effects. In other words, whether it went further than the EU legislature was entitled to by imposing EU jurisdiction outside of the EU. And if I could take your lordships to Verano, at page 441, which is passages cited by my learned friend.
Sorry, page?
Page 441, my lord. Paragraphs 82 to 83 were read to you by my learned friend. And then in paragraph 84, it continues, the correct analysis of the relevant CJU case law is that Regulation 261 imposed a contingent liability on Air Canada when it operated the flight from Heathrow, namely a liability to pay compensation to Miss Verano if she experienced relevant delay in respect of arrival at the final destination. It is common ground, therefore, that the delay at final destination, Boston, was over 5 hours. The liability therefore crystallised in this case. And it goes on at paragraph 85 to state that, contrary to the submissions of Air Canada, the existing case law has held that such an interpretation of Regulation 261 is not precluded by the territoriality principle. As explained by Lady Justice Arden, paragraph 77, the basis of jurisdiction asserted over non-community carriers is territorial. It is sufficient if Flight 1 begins in the EU, as Article 3.1 requires. It is irrelevant whether the delay was caused within jurisdiction or outside the jurisdiction. The contingent liability was imposed when Air Canada was within the jurisdiction. And the reason I cite that, my lords, is that I think that this is really key to understanding both Gahan and Verano. The point being made here is whether a carrier has brought itself within the territorial scope of the regulation. It has. And the logic given in Gahan was that it had done so by operating Flight 1. But contrary to what my learned friend said, there is no reason why that should be limited to the first flight in a series of connecting flights. It would, in my submission, be equally applicable to any flight. What Gahan and Verano are concerned about is whether or not the EU is imposing its legislation on carriers operating outside the EU inappropriately. And in circumstances where the carriers have operated a given flight, it doesn't, in my submission, matter which of the connecting flights that is. It's any of the connecting flights. So you have the first position, does the regulation apply? That's Article 3, and it's determined by whether or not a carrier has operated a flight out of the EU or whether the carrier is an EU carrier. And then you have a second question, which is, given the answer to that first question, is there a liability to pay compensation? And if so, how should that compensation be calculated? And my lords, I'd submit that this is made very clear by the case of Schenkel, which my learned friend took your lordships to in some detail. I just wanted to pick up a few of the points that my learned friend made about Schenkel. So first of all, if I could take you to page 77 of the authority bundle, which is the passage cited by my learned friend from the Advocate General's opinion. And this is the point made about the difference between flight and embark on a flight at airports and depart. And while I accept that there is always going to be limited use with Court of Justice judgments in trying to parse them too closely, I do think that the emphasis on the word flight in Schenkel is quite important, and I'll come on to exactly why later. If I could turn now to page 80 and to the Advocate General's opinion at 31, you see there that the Advocate General says the natural meaning of the expression embark on a flight in
This is new. This isn't something that we were taken to.
No, I apologise, my lord. I refer to it only because it elaborates on what was said earlier about Articles 6 to 8.
Where are you?
Paragraph 31 of the Advocate General's opinion, page 80. And the point being made here is that both the expressions embark on a flight at airports and depart from an airport refer to a particular one-way journey by air. If one is considering the return flight of a round trip, and I'd emphasise the word flight there, the departure of the initial outward flight is history. Someone boarding a return flight from Singapore to Rome is not normally described as embarking on a flight from Rome, nor are they departing from Rome.
Seems very sensible.
Oh, I agree, my lord. And the reason I raise this is because if I could then take you to page 89, which is the judgment, and paragraphs 23 to 25, you see why the concept of flight matters for these purposes. Because the word flight appears in the German, and because, as my Lord the Master of the Rolls has pointed out, all the versions of the regulation are equally authoritative in all languages, which is a somewhat difficult position to adopt, but nevertheless, you have the Court of Justice placing considerable emphasis on the word flight because it helps elucidate the meaning of depart. So it says at paragraph 23, referring to court uses the term flight and refers to the concept of journey or travel. In paragraph 24, the concept of flight is of decisive importance for answering the question put, despite the fact that, although it appears in the German language version of Article 3.1a, a clear majority of the other language versions of that provision do not refer to it or use a term derived from the word flight. And then at paragraph 25, as the Advocate General observes in point 8 of her opinion, passengers departing from an airport located in the territory of a member state or in a non-member country are necessarily passengers embarking on a flight departing from such an airport. That divergence in various language versions therefore has no effect on the actual meaning. In other words, what you have here is the court looking at the German, saying it informs the meaning of depart, and that passengers embarking on a flight are naturally those departing from an airport. In my submission, my lords, that should be read plainly. Where a passenger departs from an airport, where a passenger embarks on a flight from an airport in Europe, they fall within the territorial ambit of the regulation. And then, as I've already stated, the next question is, what compensation, if any, are they entitled to? And then, of course, with the case of OI, the key point was that there was no delay on arrival, so the issue simply didn't arise. And my lord, I thought this might be an appropriate point to answer a question that my Lord Justice Stuart-Smith raised about whether there's any relevance to the phrase passengers departing as opposed to flights departing. In my submission, my lord, all that does is reflect the interest of the drafters in the status of passengers, which you see continually reflected in the case law. They're interested in the situation of the passengers, not in the situation of the flights. And what you have is circumstances where the court and the legislature are interested in the position of individual passengers and the inconvenience that they personally suffer, not in the case of the position of any particular flight, except insofar as that grounds the territoriality of the regulation. My lord, those are really my submissions on Schenkel, apologies, and I don't propose to say much more on that point. I would like to note, really in passing, the points made by my learned friend on Wegener and Chesky. Now, we've already had my submissions on those cases, and I do accept that these are difficult cases to read and difficult cases to interpret. But I wanted to make a couple of points, if I can just find the relevant notes on this. Yes, the key point I wanted to make was just to pick up the point that my Lord the Master of the Rolls made earlier about whether or not Article 3.5 is really the key relevant position. And note and accept, of course, what my Lord says about Wegener dealing with Article 3.1a, and state that, as I stated earlier, that's because 3.1a or 3.1b is always going to be essential to a passenger falling within the scope of the regulation and thus being able to claim compensation in the first place. I would completely accept that in a situation where, on the face of it, a trip could never come within 3.1a because a flight had never taken off from an EU airport, then there would be no claim for compensation. But the fact that a given flight has taken off from an EU airport tells you no more than that Article 3 is engaged. And then you have this separate question. And that's all Wegener is really doing. It's saying, we look at compensation taken as a whole, taking the unit of flight as a whole. We look at the inconvenience suffered, we look at the delay suffered by reference to the passenger's trip from point A to point C. But when we're looking at whether the passenger has come at all within the scope of the regulation, we have to look, in my submission, at whether or not there is any flight that could fall within Article 3.1a or Article 3.1b. If there is, then that's fine, and then you look at the unit as a whole. But for the purposes of the individual question of whether it falls in the territorial scope, you look at the individual flights. And that's perfectly consistent with the Court of Justice's ruling in Wegener, and it's perfectly consistent with the Court of Justice's later points in Chesky and OI.
I think that would all be very good if it was what Wegener actually said.
Well, I understand that, my lord. And there may be a point that...
You know, Wegener actually says, in paragraph 25, the answer to the question is that 3A must be interpreted as meaning that the regulation applies to a passenger transport effected under a single booking and comprising between its departure from an airport, etc., a scheduled stopover, whether that's a technical term or not. And that is diametrically opposed, I think, I'm afraid, to what you say, isn't it?
Well, my lord, I wouldn't say it's diametrically opposed, because I would say it's, in a sense, self-evident. I mean, given the reasoning in Wegener, Article 3.1a does apply to this, because you can, for the purpose of compensation, take the flight as a whole, and because Article 3.1a is engaged by the flight that took off from the EU. Now, I accept that the Court of Justice has phrased that in a way that doesn't naturally lead entirely to that conclusion. But I would invite this court to either read down Wegener or to read Wegener in the way that I propose it should be read and say what the Court of Justice really meant here, as the Court of Justice is fond of saying of itself, is that the flight did fall within 3.1a because there was a flight that took off from the EU. It is irrelevant that that was the first flight. It could have been the second flight. It could have been the third flight. It could have been any number of flights in any number of series of flights. The regulation, therefore, was engaged in the first instance. There was a delay suffered. That delay led to delay on arrival at the final destination. The inconvenience suffered was measured by reference to that, and the claimant got compensation in accordance with that. And that really is what I submit should be the outcome of this case, so far as Wegener is concerned. It's to say that Wegener can be read down, reinterpreted as entirely compatible with the situation of the appellant in this case, but that it's not immediately clear, and I accept that it's not immediately clear, from the wording of the Court of Justice in Wegener, that that was what the court meant. But I do think that that comes out more in the decisions of Chesky and OI subsequently. And I certainly think that the interpretation I propose is entirely consistent with the Court of Justice's reasoning in Schenkel, and in particular, the reasoning that you couldn't take a single journey there and back as one unit, that you had to look at that in terms of individual flights. My lord, I would note on that point that insofar as there is a judgment that is inconsistent with all of this, it is Wegener. Wegener is the judgment that causes these issues. This is why my second ground is, if necessary, this court should overrule Wegener. Without Wegener, we wouldn't be in this position. Schenkel would have sat quite happily alongside the other judgments, and we wouldn't be where we are today. I do grant that overruling Wegener might cause knock-on effects, in that judgments that have been based on Wegener might themselves be problematic as a result of that. But I would submit that the logical position is that if a flight departs from the EU, it should be covered by the regulation, in the ordinary meaning of the term. My lord, I don't propose to say much more on the other points I had about protection for passengers and equal treatment, unless it would assist the court to do so. I believe that the court has my submissions on those points, and that they're relatively straightforward. The only point I'd reiterate is that at 46 in Fockett's, Air France and Fockett's, that the principle of passenger protection can justify even substantial negative economic outcomes for individual air carriers. And I wouldn't say anything beyond that. I think that really encapsulates the approach that the Court of Justice has taken when interpreting this regulation. Finally, my lord, I understand that my instructing solicitor has Google translated the opinion of the Advocate General in the recent case of Air Help. I don't propose to say anything about that for the simple reason that my learned friend hasn't had an opportunity to see it, and it would be unfair on him to say something when he's had no opportunity to reply. But I would propose that we send round the translation we've got to the parties and to you, my lords, so that you can look at it yourselves and see if it assists you in reaching your conclusion.
Would you say it assists us in reaching a conclusion?
I would, my lord, personally, and I can read to you the passages that I would say would assist you if that would be helpful for me to do so.
Which are they?
I'll just go to the relevant passages in the English, which should correspond to the French or the German.
I still don't think we've got the electronic French copy, but anyway.
Oh, I do apologise, my lord. So, my lord, I think this is really dealt with at paragraphs 42 following, which starts, and I'm reading from the Google translation here, the court's recent case law on single reservation does not contradict this interpretation. That case law relates to connecting flights when, contrary to the facts of the main proceedings, one of the flights, taken separately, does not fall within the scope of the regulation. This emerges, first of all, from the Wegener judgment. The case giving rise to this judgment concerned a flight with a single reservation from Berlin, and therefore from a member state, to the final destination of Agadir, located in a third country, with a connection in Casablanca, located in the same third country. The passenger missed the second flight from Casablanca to Agadir and was more than 4 hours late on arrival at his final destination due to a late takeoff from the first flight in Germany. The second flight, from and to an airport located in a third country, was not covered by regulation number 26104. The court considered, basing itself on the Foucault's judgment, paragraph 13, that the delay must be assessed for the purposes of compensation in relation to the time of arrival at the final destination, namely that of the first flight. It ruled that it follows from the words last flight that the concept of connecting flight must be understood as referring to two or more flights constituting a whole for the purposes of the passenger's rights to compensation provided for by the regulation. As regards transport with a single reservation, such as that which gave rise to the Wegener judgment, the court held that it must be regarded, taken as a whole, as a connecting flight which falls within Article 3, paragraph 1a of that regulation. I observe that taking into account flights as a whole departing from an airport located in the member state, in this case Germany, and final destination at an airport located in a third country, in Morocco, made it possible to consider that the passenger was entitled to compensation, whereas taken separately, the second flight, departing from and bound for an airport located in this third country, did not give rise to the right of compensation. This solution clearly contributed to guaranteeing the high level of protection provided for by the legislator. A similar approach was subsequently adopted in the České Aerolíny judgment and in the KLM ordinance. The case giving rise to the České judgment concerned a flight from a member state, and it summarises České. And then it goes on at paragraph 50. The court underlined that this solution is justified by the objective of ensuring a high level of passenger protection in order to guarantee the passengers transported are compensated by the actual air carrier having concluded the contract of carriage with them, without having to take account of the arrangements made by the latter with regard to the performance of the flight making up the connecting flight which it has marketed. I therefore consider, like the Commission, that this case law contributes to the achievement of the objective of the regulation, of guaranteeing a high level of protection by interpreting that regulation in the sense that it also applies when the whole connecting flight contains a flight to which the regulation would not apply if this flight were considered in isolation. On the other hand, I agree with that institution that there is no need, and this is the key part, there is no need to apply that case law by analogy to an air link comprising two flights such as that at issue in the main proceedings. Such an application would, in my opinion, comply neither with the letter nor with the objective of Regulation 26104, insofar as the latter is already applicable to the two flights considered separately, and where this application would lead to the opposite result to that pursued by the legislator. Taking into consideration, in such cases, flights as a whole, taking into account the places of initial departure and final destination, both located in a third country, would restrict the protection conferred by that regulation by depriving the passenger from any protection under that regulation, even though those flights carried out by a community carrier include a point of departure or a point of arrival in the Union and therefore fall within the scope of the regulation. Now, and it goes on to say, in other words, I consider that the case law analysed in the above area of single booking cannot exclude from the scope of Regulation 26104 a situation which is clearly covered by it. Apart from the fact that such an application by analogy would run counter to the wording of Article 3.1 of the regulation, it would have results which are at least paradoxical. Now, my lords, I completely take into account the fact that this is concerned with the community carrier.
And what are the facts? Because we haven't had those, other than I spotted that it was to do with community carriers.
Absolutely, my lord. I'm just finding the relevant facts. Thank you. So the passenger, this is from the request for a ruling on the second page. The passenger had a confirmed booking for the air route which ran from Chisinau to Vienna and from Vienna to Bangkok. Chisinau is, I think that's in the Ukraine, but I could be wrong. I don't know where that is. But the point is, both the flights, there were two flights, one from a destination outside the EU into the EU, and then from the EU out of the EU. I would submit this is a case.
And both are with an EU carrier?
Both with an EU carrier.
So what was the issue?
So the issue
that the court was deciding? Very old-fashioned, but I always quite like to know what the issue was that the judgment that you then read to us goes to.
Absolutely, my lord. So the question that was referred was as follows. This is page 1 of the request for a preliminary ruling. It says, must Article 3 of the European Parliament and the Council, etc., establishing common rules on compensation and assistance to passengers in the event of denied boarding and cancellation or long delay of flights, be interpreted as meaning that the regulation also applies to an air route booked under a single booking, but consisting of two flights, both of which are operated by, brackets, the same, community air carrier, if both the place of departure of the first flight and place of arrival of the second flight are in a third country, and only the place of arrival of the first flight and the place of departure of the second flight are in the territory of a member state. Now, my lord, I would note that this is a community carrier, but submit that in practice, given the facts of this case, it wouldn't have actually made any difference, because in my submission, the second of those flights, operated from Vienna to Bangkok, would have brought a non-community carrier also within the scope of the regulation, in that a non-community carrier operating that flight would have fallen under the provisions of Article 3.1a. So notwithstanding that this is dealing with Article 3.1b, the same position would occur under Article 3.1a were this a non-community carrier.
And that's the issue for us.
It is absolutely, my lord. I don't see...
I mean, so far on that analysis, what is said, although I notice they don't go to the later paragraphs of the judgment in Wegener, they stop again, I think at this time at 15, so they go slightly further than the last case, but not that much further. But leaving that aside, on the face of it, again, it's not altogether a surprising result, but it doesn't seem to me to be, well, it's certainly not analogous to this case, because it's concerned with whether Article 3.1 catches this through 3.1b.
My lord, I accept that, but I would make the point in response that the question is, in essence, as the court seems to see it, whether or not you take these flights as a whole. The reasoning is phrased around, do you take these flights as a whole, or do you split them up into their component parts when to do so would benefit the passenger? And in my submission, there is no obvious reason why the logic would be any different for a non-community carrier as it would be for a community carrier, on the basis that in either case you have to bring yourself somehow within the territorial jurisdiction of the regulation. So in the case of a community carrier operating a flight entirely outside the EU, or a series of flights entirely outside the EU, doesn't fall within the scope of the regulation. So the territorial jurisdiction of the regulation is relevant in both cases. It just applies in slightly different ways, in that for a community carrier, it can apply on landing at an EU airport, whereas for a non-community carrier, it can only apply when operating out of an EU airport, or departing from an EU airport, to use the exact words of the regulation. In my submission, looking at the facts of this case, that would also apply to a non-community carrier, and there is no reason, purely on the basis of the logic set out in the Advocate General's reasoning, why that reasoning would apply any differently to a non-community carrier as to a community carrier. It's not concerned with the in personam jurisdiction, it's concerned with the territorial jurisdiction, or at least it appears to be. And then, yes, and then the other point would be simply that I would fully accept that the reasoning set out by the Advocate General is a little bit have your cake and eat it in this case. It seems to be you apply the whole flight concept when it suits the passenger and you don't when it doesn't. I have attempted, through my submissions to this court today, to outline a mechanism by which that can be resolved without needing to resort to such an approach. But I would fall back on the point made here, and on my submissions generally, that the principle of passenger protection should encourage this court, to say the very least, to find a solution that benefits the appellant by extending the protection offered to air passengers. And that seems to have been the approach adopted by the Advocate General in this case.
We don't know what the court, when is the court decision expected?
My Lord, I don't know that. No. As far as I know, we don't have any idea. And certainly from my experience of Court of Justice decisions, they don't always tell you.
Well, it's likely to be 6 or 9 months away because
Exactly.
it's only delivered in October.
So, my Lord, I wouldn't invite you to wait for a decision of the court, but I submit it purely as a point of interest, and to note that this may be the approach that the court takes, as it often is, as it often does by following the Advocate General.
Yes. Okay.
My Lord, I think that case makes the point set out in the German judgment as well, and so I don't propose to deal with that.
You weren't proposing to make any submissions about this.
Well, my Lord, I will make a brief submission about...
No, I meant the one that we've just had a translation of.
Am I proposing to make any submissions on that?
No. You started by saying you weren't proposing because it would be unfair on Mr. Turner. You've now made submissions.
I do understand. And if Mr. Turner would like a chance to respond, I, of course, would accept that.
Well, he'll have to have the translation first.
Yes. But yes, my lords, I propose that the best approach would be to send round this translated version to everyone. And I would also be happy for us to provide a official translation, but that might take some time.
Right, well, yes, okay.
Thank you, my lord. I just want to check whether there are any further points I wish to make to you today. No, my lords, I think you have my submissions on this case, and I hope it is at this point clear what my position is. My primary position being that this can all be read compatibly, and my secondary position being that in any case, the principle of passenger protection and equal treatment demands a certain outcome. I don't believe, unless your lordships think differently, that it would assist the court to go into anything in more detail.
Thank you.
Thank you very much.
Thank you. Mr. Turner, do you want to say something on air help? Or do you want to wait and put something very brief in writing when you've seen?
My lord, I have just done a Google Translate, and it did differ slightly, I'm afraid to say, from, not materially, but slightly from the version that my learned friend just read, which is within the nature of Google Translate. I think, to the extent that it would assist the court, if an official translation, if there is going to be reliance placed on this, one would want to look at an official translation. But I think the key points really on this
You can take your mask off. That might help
sorry,
us.
I apologise.
That would be the key point.
I apologise, my lord. The key points on this are twofold. Firstly, it is not even officially persuasive. It's not within the scheme of things which the court is even required to take into account. Secondly, as my Lord Justice Coulson has pointed out, it is not on all fours with the present case, and that is because it is an Article 3.1b case, and in Article 3.1b, the emphasis is on landing within the territory of a member state, not on the point of departure. Now, the language is the same, but the emphasis of the relevant provision is different, and I would submit that the policy concerns are different. The final point I would make on this, and I think Mr. Gillow accepted in his submissions just now, although I accept that he hasn't read it in full either, which is that the Advocate General does not give any kind of formulation of how the words departing from can be read as meaning two things at the same time. My Lord, the Master of the Roll has raised this question at the outset to Mr. Gillow as to what the formulation is. There has been some attempt to rely on Article 5.3. That's certainly not what the Advocate General does in this case. The Advocate General simply says, well, passengers should win, and so that's how we're going to decide it. But there is no logic or rigour to that decision. There's no attempt to explain how it could be consistent with Wegener. He simply says, well, let's just ignore Wegener and decide it in the passenger's favour. So in my respectful submission, this is not something which the court ought to treat as persuasive.
Very good. Good. Well, we'll take time to consider our judgments. If you could let us have whatever translations you get when you get them, that would be helpful. It doesn't seem to me, at least, that the air help case could ever be conclusive of anything, being just an Advocate General's decision. But it would nonetheless be helpful to see the translations, even the Google Translate one, for what it's worth. And I think we all have sufficient skill in French to be able to read once we know which paragraphs. Probably don't want to read the whole judgment. Once we know which paragraphs are critical, we can read them in the French. So I don't think we need to wait for an official translation. But when you get our judgments, will you please agree the consequential directions and orders, if any, and if you can't agree them, we'll deal with any dispute in writing and let us have textual but not substantive corrections. But thank you both very much for what is quite an interesting argument, and to your solicitors also. Thank you.